Hello, listeners out there. Thank you for joining us for this webinar, Advocating for Impact, Legal Advocacy, and Strategic Litigation. For those of you not familiar with the Colorado Health Foundation, our vision is that across the state, each of us can say we have all we need to live healthy lives. We're grateful to be able to work towards achieving this vision through partnerships with organizations doing great work all around the state. We also firmly believe that policy and advocacy are vitally important tools to make meaningful progress on our mission. Today, for this webinar, we have 4 main learning questions that we hope the presentations will answer for you. The first is, what kind of legal advocacy activities can nonprofit organizations consider as potential means to advance their mission, and when might this be an appropriate strategy? Second, what capacities are helpful for nonprofits to be ready and able to engage in strategic litigation and other types of legal advocacy? Third, what resources are available in Colorado specifically to help nonprofits partner with other advocates and legal experts? And finally, what can we learn from Colorado nonprofits' successful engagement in legal advocacy? As a quick note, in other areas of advocacy, there are strict limitations and allowances for nonprofits and C3 organizations who engage in lobbying and other advocacy efforts. However, in this case, there's no need to dive into the legality of nonprofits engaging in this space because all efforts under legal advocacy are not lobbying. So the technical definition of lobbying is that it's an attempt to influence specific legislation, for example, bills introduced in the state legislature or ballot measures. So 501c3, that tax status does not restrict a nonprofit organization's ability to engage in legal advocacy or litigation. So it's a very wide open space, legally speaking. So for this webinar, we're incredibly lucky to be joined by a group of presenters who will share their in-depth knowledge and experience with legal advocacy work and strategic litigation. First with us is Deepti Sood, a senior consultant with the TCC Group, a national consulting firm working to address complex social problems by helping clients strengthen strategy, build capacity, and advance evaluative learning. Next, we'll hear from Kevin Williams, Legal Program Director at the Colorado Cross Disability Coalition, Andrew Montoya, Legal Program Attorney and Andrew Montoya, Legal Program Attorney with CCDC. Finally, Connie Talmadge, Executive Director with the Colorado Lawyers Committee, expertise and expand on the great work that the Lawyers Committee is doing in Colorado. So we'll go ahead and get started with Deepti.
Great, thanks, Sarah. So what I want to cover is really just a few main overviews to legal advocacy. So first, sharing what legal advocacy is and isn't. Secondly, going through how legal advocacy work and litigation can complement other more traditional advocacy strategies. Talking about readiness to engage in legal advocacy, both for individual nonprofits and also for different content issues or for coalitions. Talking through challenges people working in this space might want to think about, and then finally, how to work with funders so they can better support this issue. So what is legal advocacy? You can see from the quote on this page, so what stands out here is what we put into the legal advocacy bucket is everything. And there's really a lot of work to put this into context. TCC Group, in partnership with Atlantic Philanthropies through the Atlas project, did a whole scan into how funders and nonprofits across the country are thinking about and using legal advocacy either as a funding strategy or as a strategy to advance their own mission and vision. And one of the things we often heard from people is this sort of gut sense that legal advocacy just means litigation, but it means a lot more than that. So it can be litigation, actually bringing a lawsuit or a case forward in a court system, but there are also a lot of other things we can look at. And so some of those things include research and publications, so conducting data analysis or new research focused on what's happening in the field, what are certain types of populations or geographies experiencing, and just getting more data around the situation on the ground, and maybe publishing that a little more broadly so other people interested in this space sort of have the data they need to really get started. A second thing is writing draft policies. So it could be working with legislators, with others, to just advance policies that you think could address legal issues that you're seeing in the ground in a way that makes the playing space a little more equitable for different populations. Another is administrative or executive advocacy. So sort of working through the regulatory system to say, here's a statute that's being enforced unfairly, and we have data to show that's true, and this is how we'd like to remedy it. Fourth option is writing amicus briefs. And these are briefs, you can sign on to them as a non-lawyer, so sort of as an organization. Typically lawyers write them, but they essentially bring in different arguments into an existing court case. And they're often very helpful because they can expand the range of issues or ideas that's sort of being focused on in a certain lawsuit. Another is legal support or legal aid. This is often more sort of on-the-ground assistance to individuals, but can, in certain instances, if you're seeing a problem is really widespread on the ground, you can sort of roll up information into a class action lawsuit that works more effectively on behalf of a specific population or group of people. And the last thing is litigation. So this one mostly goes without explaining, but is essentially bringing forward a case, a lawsuit through a court system, often chosen very sort of clearly and particularly because the court system there is a little more open. It might be a region where you know a lot of people are sort of suffering from unfair treatment and is meant to create sort of a remedy for the situation that applies to all people, not just the people bringing forward or the plaintiffs on the lawsuit. And so one of the things we really like to emphasize around legal advocacy is that it should not operate in a vacuum. You can see in this diagram, we've outlined a few other complementary strategies that we often find advocates are using. And legal advocacy, when used in connection to these strategies like media, public awareness, grassroots organizing, and other more traditional forms of advocacy, really has the potential to make a lot of impact. One of the ways we like to explain this is thinking about winning a lawsuit versus winning in the quote-unquote court of public opinion. And that's a sort of really clear way you can think about certain situations like Brown versus Board of Education, a series of cases that focus on school desegregation. They won in the courtroom. They did not necessarily win in the political opinion of that time, and that led to a lot of backlash, a lot of fighting, actual closing of public schools, because individual people weren't really bought into the solution that was imposed through the court system. On the other hand, you can think about marriage equality, which in some ways was sort of won through public opinion before it was won in the Supreme Court, and had a very different sort of reaction and experience when the ultimate case was decided. So I just want to take a few minutes now to talk about readiness. I know one of the goals for this webinar is to help organizations who might be newer to legal advocacy sort of understand when does it make sense for you to engage, what are the sort of different roles you can play. So we want to talk about, is your issue area ready for legal advocacy? And then is your organization ready to engage in legal advocacy activities? So one of the things focused on readiness we'll talk about, and these are all pretty straightforward but essential, are these four criteria: funding, communication, legal expertise, and research. Funding is essentially just having the monetary resources and support you need to do the work, whether that is hiring lawyers, whether that is sort of food for coalition meetings, just making sure you have the funding, ideally multi-year funding, ideally general operating support funding, to have flexibility in terms of moving some of these strategies forward.
Just a quick question.
Sure.
You mentioned several different types of options that are available beyond litigation or acting through a legal program of some kind. Is it your view, what we found is legal advocacy is probably one of the most expensive avenues for solving the problem. Would you agree?
I think often litigation is a very expensive avenue in terms of having lawyers, having expert witnesses, having lots of sort of travel and affiliated expenses often. But I think the other periphery elements don't necessarily need to be very expensive. Writing an amicus brief can be done by a single lawyer. There are sort of some ways public education and awareness can often be done through existing channels. Research can often be done fairly cost effectively. So I think litigation is expensive, but there are ways to get involved that are not necessarily so expensive.
And one other question, on amicus briefs, often we as an organization sign on to a brief and some other attorney is going to write it eventually. We may agree with the, whatever the purpose is, and we just sign on and send a statement of interest. So, I mean, that's something that you can do that's simple and effective and doesn't involve your organization actually getting involved in writing a brief.
Yes, absolutely. So it's something you can do to signify support where you don't necessarily need deep legal expertise within your organization to do so. Absolutely correct. To think about communication, just being able to sort of share information publicly, whether that's in a press conference, through a local newspaper, to sort of frame the issue, the case you're making in a way that moves it out of the legalese environment and into something, everyday people understand, sort of the human interest aspect of it. Legal expertise, of course, you don't necessarily need it in your own organization, but if you're working in a coalition focused on a specific issue area, ideally some of the organizations will have that legal expertise. And I know today we'll hear from some organizations based in Colorado who really have a wealth of experience that they're willing to share with other nonprofits. And then finally, access to research. We have found that it's very helpful for organizations to have an understanding of what's actually happening on the ground before they bring a case forward. So you don't want to get into a situation where you say, we think this is an issue and someone's civil rights are being violated, and you are wrong. And there is the potential, because you're in a court system, to create bad precedent. And so you really want to sort of do your homework around how has the court system traditionally dealt with issues like this? What are arguments that other people have? Who are the judges we might get, and what are their individual biases? And just sort of do your homework around the entire context of the space. Another readiness characteristic is a clear vision for the work. None of this is that surprising, but just really maintaining that you have a clear vision around what actions you're comfortable taking as an organization or your board members are comfortable with. Having a clear vision for how legal advocacy intersects with other strategies the broader movement is using, whether you are using those strategies or just others working on the issue are using those strategies. And just sort of having a goal in mind in terms of, if we are bringing this case forward or if we are engaging in this action, what's the end goal and why is it worth our effort? In terms of legal readiness, so this is sort of a funny New Yorker comment. Legal readiness, some of this we already talked about, but you really want to have sort of the expertise ready, whether it's in-house, whether it's through pro bono lawyers, to know that you have the structures and resources in place to sort of push the legal arguments forward. And then to talk a little bit about challenges, we've bucketed these into 4 main areas: movement and coalition challenges, resource challenges, motivation challenges, and legal challenges. In terms of movement challenges, what you really want to figure out is the right role for your organization to play in the movement versus other organizations. It might be that in the content area you're working in, there's sort of already organizations that have really great legal expertise, and you can tap into them and sort of play a periphery role where maybe they are working on the court system and you are really working on that public awareness piece, and so you're complementing each other, but each organization has a pretty clear niche in this space. In terms of resource challenges, Again, just access to funding. We have heard from many nonprofits this is one of the most difficult things in terms of bringing legal advocacy actions forward, and typically is not done through grants focused on the litigation, but done more often through general operating support grants that organizations can use for strategies that really make sense, sometimes but not always, including litigation. In terms of motivational challenges, again, just being able to keep that long-term commitment in mind. Often, if you are involved in actual litigation, it will be a multi-year process, and once you sort of have a verdict, there will be an appeal.
Will be.
There will be an appeal. So really making sure you sort of have this commitment to carry the case through. And a lot of things could happen. There could be a big dramatic national election no one saw coming, which could sort of change how the court system is operating. And so just sort of thinking through some of the different long-term options that might arise and feeling prepared to address all of those. And then also, that's also true in terms of your plaintiff. So most often a litigation case, whether it's class action or not, will sort of have a few public plaintiffs who are saying, this is an issue that I have been affected by, and I have legal standing to bring this forward, and I would like the court system to address it. And that can be sort of a tiring role. You're in the public eye a lot. Sometimes there are smear campaigns or other bad publicity. And you really have to sort of make sure that whoever's the public face of that feels comfortable and is really bought in that, you know, they are ready and they're pushing us forward and they really care and they're in it for the long run.
Again, just talking about different strategies, we find, and I tell without waiving privileges, what I always say, but I tell my clients that litigation is probably one of the slowest ways to get something accomplished. Is that an experience the organization finds? I mean, there are many other ways to get things done, and litigation is often the slowest. Yes,
yeah, I think that's true. And I think also for individuals, there are easier ways to resolve your own individual situation.
Do you need less hard on the individual?
Yes, less hard on the person. So maybe like some outside of court settlement, or some agreement that's worked on. Where both sides agree and it doesn't involve lawyers and juries, judges, because yes, bringing a lawsuit forward is slow and it takes a lot of work.
And
there will be an appeal. And then finally, just in terms of legal challenges, I will let the lawyers at this table speak more about this. But again, just thinking about things like precedent, standing, making sure you sort of have the legal rights and readiness to bring a case forward. And then finally, just want to spend a few minutes sharing what funders consider. So as I mentioned, we did some research on this project that involved talking to about 20 nonprofits and 20 funders who are really deeply involved in legal advocacy. And so we wanted to take this opportunity to share what we heard from funders in terms of what they think about before they fund legal advocacy work for nonprofits. And so none of these bullet points I think are very surprising, but they really look at things like your own organizational reputation, your legal capacity, the strength of your leadership. And really they just want to know, not will you win, because we don't know, right? It comes down to lots of different elements and contexts. But they want to know, do you have the capacity and the organizational strength to sort of choose a strategy, follow through on it, make a really good effort? You're sort of the best organization positioned to do that work. And if you win, it will significantly move forward an issue area that you've been working on and that the funder has been working on.
I keep being the only person to ask questions. In any event, I see one of the things you've listed is strategic alignment. And what we found, our organization at West Colorado Cross and Civility Coalition, and our litigation program engages in nothing but civil rights advocacy for people with disabilities. And strategic alignment, I mean, essentially, we might bring a lawsuit against anybody. I mean, you know, it's conceivable. And so when we're dealing with funders, we have that issue where, you know, they're really concerned that is there somebody that we're aligned with, that they're aligned with, that we might, bring a lawsuit against? I mean, we bring lawsuits against entities that violate the ADA or whatever. Do you find that as being one of the larger things that funders consider when providing?
It's a great question. We actually didn't find a lot of that in our research.
We do.
Yeah, so I totally hear that you do, but it's a very interesting question in terms of how to sort of make sure that the funder has enough buy-in to the work that you all are trying to do and the long-term impact and outcomes you're trying to achieve. And imagine, right, there might be a way to sort of raise that up and get around some of the sensitivities of, okay, do this for everyone, but not for these 5 groups who are really in our close ones. And
we'd be happy to fund you as long as you don't bring a lawsuit against.
Right. Yeah. So I would think some candid conversations with right, the potential program officer and the program officers around, this is what our organization does, this is our long-term outcome, and these are sort of the barriers that we're trying to erase. Great. Thank you all very much.
All right, move on. Yes, please go ahead, Kevin and Andrew, Colorado Cross Disability Coalition.
All right, thank you, Sarah. I'm Andrew Montoya with the Colorado Cross Disability Coalition. Along with me today, of course, is Kevin Williams. And I think we're skipping ahead a little bit on the slides there. What the CCDC legal program does, which is where Kevin and I work, is it engages in civil rights litigation on behalf of people with disabilities, as Kevin just alluded to. And that really comes from a long history of civil rights law that is not intended to be enforced by the government so much as it is private litigants. So what we do in the CCDC legal program is essentially function as private attorneys general for people with disabilities in the enforcement of the ADA and other disability rights laws. Of course, CCDC does a lot of other work, and I'll turn it over to Kevin to discuss some of that.
Okay, and I think, our organization, it's funny, Laura, who's now with us, was going to cover these couple of slides. But the broader organization involves, involves our legal program, which is the 3 of us sitting here today. There's an individual advocacy component of the organization. Systems advocacy. Did I do something wrong?
The slides have a mind of their own.
Gosh, what do you do to keep it from jumping up?
The slides are just jumping.
Oh, okay, all right. And we also do advocacy training. That's a big part of what the organization covers. And also, we just started our legal program does one thing. We handle civil rights cases for people with disabilities. So there's a wide array of things that you might consider legal activity that might be attached to disability. That's not what we do. We handle disability rights cases, but we have started a new, it's called Probate Power. We just started that program and very happy with it. And so what we're doing with Probate Power is assisting people with all those issues that happen related to anything from setting up trust of estates, Medicaid trusts, those kinds of issues that people with disabilities encounter. We just brought on a new attorney who does that, and it's so funny. He's in a cubicle actually across the hallway from my office. But we really never talk because our programs are very, very different. But I think I've gotten. Let's see. We covered. The organization was founded in 1990. I actually had hair when we started, and we have, I'm told by the slide, 2,800 members statewide. So we are a membership organization, and we do represent in litigation both our individual members and the organization itself. A lot of times we will represent CCDC as an organization that helps people. Remind me of your work.
You're still on.
Okay. We founded the legal program itself in 1997. And that actually, well, I can tell you it was May 15th of 1997, which is the day that I was sworn in as an attorney practice law. And kind of the reason that happened was we worked very closely at that time with a law firm that was then called Fox and Robertson PC, and they it's a husband and wife law practice, and they both work for large law firms, and we're real happy with that work, and decided to open their own firm. And so it happened right at the same time that I got out. We had some discussions and decided it made a lot of sense to have an inside lawyer within the Colorado Cross Disability Coalition. I'll call it CCDC because it's too hard to say. To have a lawyer inside. And it was also helpful for me because I was able to use their mentorship to get things going. As I said, we handle disability related civil rights cases. We also do consulting. We don't get asked as often as we think we should. That's kind of I suppose, not the best way of putting it, but we do get asked to do consulting more often than we used to by businesses who want to come into compliance with the ADA, and they want our input. I would say what I've run into is, I mean, Andrew and I are both very extremely well versed in the laws that apply to the civil rights of people with disabilities, but we're not engineers and architects. So if you're dealing with, for example, an issue of design and construction, you probably want to hire somebody who has expertise in design and construction, and perhaps have somebody who's a lawyer involved in that process as well. We have, I can't even, our website's going to be available all over the place, and if you log on, you can go into programs, legal, and find all the cases that we've done. But we have literally either by demand letter, litigation, other means, sometimes maybe administrative law channels, litigated or resolved hundreds, probably 200, 300 cases, and then been there a long time, 21 years. So, and then I think to look at a minute some more of the highlights and lowlights of litigation. We do try to bring what we call impact litigation. The idea being, you know, if we can bring a lawsuit that is going to do more for more people, let's do that instead of bringing a lawsuit on behalf of an individual that is going to only resolve one problem. I can't say that we're always successful in accomplishing that. A lot of times, sometimes, I'll give you an example. Lately, people with service animals have been coming to us frequently, and it's a real tricky issue. I'm probably the worst at saying, come on, because they're really a service animal. But, so, you know, we learned that problem a lot, but it's one of those areas where you may not find a whole large number of people involved, but you bring, you know, one case against one entity, say a large store chain or something, and you win that case, and they obviously are going to appeal, and you win that appeal, and you're successful, then other store chains are, you know,
another way of doing a large impact litigation is dealing with a large venue. For example, here in Colorado, CCDC legal program has been involved in suing and I guess resolving, because not all of them, I don't know, have been litigation, but in resolving seating problems, for instance, at a lot of the large venues, and we've got pictures up there of Red Rocks. We just actually recently settled a case with Red Rocks about wheelchair seating in the front row. It was being overrun by people who would, they would essentially buy scalped tickets for 10 times the face value just so they could have front row seats, rendering it unavailable for people with disabilities. Coors Field is another large venue that CCDC has been involved with. The Pepsi Center, I believe Invesco Field as well. As Kevin reminded me, probably everything in the state of Colorado with the exception of Dick's Sporting Goods, and that's simply because we haven't had a complaint about Dick's Sporting Goods. But this is a great example of how one problem for one individual can spawn changes that affect people all over the state, and in fact all over the country, who may come to Colorado to enjoy some of these large venues. Any individuals in wheelchairs will benefit from the changes that we've made by engaging in this legal advocacy.
Okay, next, in talking about impact litigation and sort of large impact cases that we've worked with, one thing that we hear all the time is, you know, if you had only let us know beforehand that there was a problem, we would have solved it. And you know, it's been 27 years since the ADA's passed, and some of the other laws that we deal with, it's shocking, isn't it? People are still, the notion of service animals I've talked about before. We're doing a lot of cases. Up on the slide is a sheriff's badge, and we've been dealing with a lot of cases lately involving individuals who are deaf and not getting sign language interpreters in the law enforcement context. And again, it's, you know, I have to say it's 27 years after the passage of the ADA. I don't know when our first case came in. It hasn't been that long ago, but we've had, it's sort of once we bring one, the floodgates open. And so that's an area of impact litigation where we can bring a lawsuit against one, say the sheriff of fill in the blank, we sued Arapahoe County as an example. We got the Department of Justice involved in that case, and we were able to settle it and under terms that require them to provide interpreters in all sorts of settings. I mean, there's all sorts of things that law enforcement does. Everything from the initial contact all the way through incarceration and so on. And so we had to deal with all of those things. There has been a great deal of lack of voluntary compliance, and that's, like I said, those are two areas that I've talked about that you just can't figure out. And this, you know, why 27 years still dealing with these issues. And then the issue, the picture that we have on our slide that won't be in the recording is a picture of, it's hard to see, it's somebody sitting on a light rail train.
Or sitting in a cafe with a light rail train moving behind them.
There you go, Andrew, as you can tell, put the slides together. But anyway, I wasn't smart enough to ask that question. But in any event, we've been involved in litigation. This is an example 3 times with RTD for different issues, but all having to do, with wheelchair seating. It's been buses. We just settled on light rail trains. And so again, I mean, when we say impact litigation, we're talking about RTD is going to make all of its trains, the ones that are in existence, accessible, and the purpose are going to be accessible. From what I understand and from what we've heard, they've done a great job so far with the ones that they've changed. But many of our members are people who use wheelchairs and use public transportation. So if we're able to resolve a case like that, it has a large impact on a lot of people.
So just to kind of touch on the Gang of 19 there, for those who may not be familiar with the Gang of 19, the Gang of 19 was a group of 19 wheelchair users who, I forget the year, Kevin, perhaps you can help me there, but
it was before the ADA passed.
Before the ADA passed. They shut down traffic essentially in the heart of Denver, right at the intersection of Colfax and Broadway, by literally crawling out of their wheelchairs and laying in front of the buses to prevent the buses from moving on their route in order to protest the lack of accessibility on the buses. At that time, there were no ramps or lifts to get wheelchairs on buses. rendering the entire system unavailable to people with disabilities. Even with a beginning like that, we still, as Kevin talked about, have had ongoing issues with RTD that have resulted in 3 additional lawsuits. That also follows multiple meetings from advocates on all levels, different committees, individual meetings, things of that nature, trying to resolve some of these problems before they wound up in litigation. But in some cases, there seems to be some institutional pushback, institutional resistance, I guess, to doing what we're asking in complying with the ADA.
I guess we find that to be more, it occurs more with governmental entities, it seems to, than with private entities. I don't know why, but they just seem to like to fight. And by the way, that Gang of 19 issue protesting as opposed to litigating resulted in Denver being the first city in the country that had whips on its protest. All right, so moving on, we are, let's see.
Yeah, moving on, some of the wins that we've had, this isn't so much a particular case, but it's an issue in which we've had a lot of success, and that's communication for deaf individuals in a whole, a whole slew of areas. Primarily, our focus has been law enforcement, medical settings, whether it be a hospital, an individual doctor, an emergency room, what have you, and in other settings such as adult education, telephone banking. Got a quote up there. He even made a sign for tree that I could understand. That quote comes from one of our cases against the Boulder County Sheriff's Office and the Longmont Police Department. In that case, our client was a deaf man who had police come to his door. I'm not going to get into a whole lot of the backstory, but the police came to his door. He offered the police officers a card that he had received from the Department of Justice that specifically talked about law enforcement's obligation to provide sign language interpreters to deaf and hard of hearing individuals. The police were investigating this man as a suspect, and the quote, he even made a sign for tree that I could understand, was a quote from one of the officers' reports after they refused to provide a sign language interpreter because one of the officers knew some sign language. They proceeded to arrest our client for making a sign that the officer understood for the word tree, because that fit the narrative that the person who called the police officers had provided. Our client, however, was attempting to sign something that's the equivalent of protest. It's kind of a swipe across the forehead and throwing away the sweat, so to speak, as a sign of protest. The officers understood that to mean tree, and beyond that quote, the officer went and detailed the sign in court that the police ultimately used to prosecute our client. We were able to show, of course, in the course of litigation, that that's not at all what the client meant, and that in fact is a perfect example of why law enforcement needs to provide sign language interpreters for people when they're potentially arresting them.
Okay.
Sorry.
Oh, go ahead.
I'm not quite done there. Some of the things that we've uncovered in doing this litigation that really seem to help are, one, putting your focus where the rubber meets the road. That's focusing on good policies and good training. Something that's been seemingly very successful for us is literally giving the folks on the ground, whether it be a nurse in an ER or a police officer responding to someone's home or perhaps even their car after they pulled them over, giving them something as simple as a checklist to follow to make sure that they dot all the I's, cross all the T's, and provide the deaf individual with the type of communication that he or she may need. And of course, that varies with the particular individual and the circumstances. But putting our focus on making it as simple as possible for those people on the ground seems to really advance that ball. Some of the legal problems we've encountered in this area, of course, one of which is the regulations. In 2010, the ADA regulations were amended, and the Department of Justice, who's responsible for those regulations, made a change that has caused a lot of harm to individuals in the deaf community. The Department of Justice essentially has equated video remote interpreters with live interpreters. If you ask a deaf person, of course, they will go on and on about the difference. Video remote interpreting is essentially Skype with an interpreter, which may work in some settings. But again, when you're in a hospital emergency room or you're being arrested and you have no idea when you're going to be getting out, and oftentimes no idea why you were arrested in the first place, viewing someone on a small screen who may or may not know medical terminology or legal terminology is generally going to be inadequate. As a result of the Department of Justice regulations, that's a big fight that we are having now, is a lot of places are trying to provide video remote interpreting in lieu of live interpreters, and the level of communication is just not similar at all. Another big problem that we're encountering is the legal doctrine of standing. Of course, the Constitution only empowers the federal courts to hear cases that involve actual cases or controversies. And over the past couple of centuries, that's been narrowed down to mean essentially that a deaf or hard of hearing individual will have to allege that he or she will absolutely return to whatever the defendant is. In a law enforcement case, it's almost impossible for a deaf or hard of hearing individual to say, I'm going to be arrested again, or I'm going to be the victim of a crime again.
We don't advise that.
No, absolutely not. In any way that the court is going to buy sufficiently to confer standing upon that individual. So again, that's something that we're fighting with day in and day out. We're hoping to make some headway on that. But generally speaking, our cases involving deaf communications have been a big boon for our organization and for deaf people across the state.
One thing I wanted to point out quickly on this slide, and then we will move on. At the bottom of the slide is a picture that is sort of the Department of Justice universal symbol for we provide sign language. It's two hands, essentially, linked together. And what we have done through litigation in this area is we've used that symbol and simply next to it put a sign saying, do we need the sign language interpreter, yes or no? And so when you approach somebody at the door, and it doesn't take much to figure out that somebody's deaf. You can present them with that document and have them check if they need an interpreter or not. And the Department of Justice actually uses it in its agreements now, so I'm kind of proud of that. But any event, next slide. Along with wins and of those, 300 cases or so, or whatever we talked about, we've resolved most of them. It's the nature of civil litigation. Most cases settle, but we've certainly had our share of losses. And I will tell you that just straightforwardly, the 10th Circuit Court of Appeals is a difficult place to bring cases, disability rights cases. It just is.
It's a difficult place to bring any case.
Sort of plaintiff-oriented kinds of cases, and it's a tough circuit, and it's something that really needs to be considered when you're looking at a legal program or looking at bringing something through legal channels. Is something that we want to appeal if necessary. The case that we are specifically referencing on our slide is it was a case involving a woman who was blind, and she was seeking fertility services. I won't get into all the details, from a fertility clinic. She was having difficulties becoming pregnant. And things were going along fairly okay until she encountered a certain doctor. And that doctor, if you look at her notes, basically lost her mind at the idea that a blind woman would even consider the idea of having a child. And so what the law and the regulations say, by the way, we members who are blind children, take care of them just fine, including my co-counsel on that case. But what happened in that case was that we proved factually, and I think the evidence demonstrated at trial, that the medical facility treated her differently than they treated non-disabled people. And what I mean by that is this doctor said, unless you come to me and bring me, and what she said was a report from an occupational therapist that says that you are safe to parent a child, that we are no longer going to provide these services. And of course, they didn't ask that of anyone else. That evidence was in the record, but what happened during the course of the case was that we kept hearing, well, we heard first from the original doctor who had been treating our client, and he used this phrase that, oh no, it wasn't her blindness that was of concern to us. We had a constellation of concerns. And I found that to be sort of an interesting use of words, but that's what he said. And then everyone else, doctors, nurses, janitors, I mean, whoever they put on the witness stand, who talked about this case, said, yes, we have this constellation of concerns about this individual person. And so we took this thing up in the 10th Circuit, and on the notion that we had demonstrated that she was forced to do something that was different from everyone else. And it was clear in the record, the evidence was there that, that we proved it at trial, and that's what mattered. But what the 10th Circuit came down on was this notion that, well, there is evidence in the record, maybe not clear, but there is evidence in the record of this constellation of concerns that suggests that, something other than blindness. Cases like that are really difficult. And, we had a jury that found that she was not discriminated against on the basis of blindness because of that reason. We find that juries are, I don't know, the easiest way to put it is weirded out by disability. I find that juries spend more time looking at the gizmos and gadgets on my motorized wheelchair than they do listening to the arguments I'm making. And so we have to deal with those issues and get past them rather quickly. Then we have sort of what we call the bittersweet situation that comes up in cases, I'd say frequently. One of them was we sued, for anybody who has, I guess, teenage kids, I think, Hollister stores, which I had never heard of before. They're owned by Abercrombie and Fitch. And we sued the store chain saying that even though they were built after the enactment of the Americans with Disabilities Act, that what they had done was inside malls, they built stairs to the front entrance. So everybody went up the stairs to get into the stores. Well, oddly enough, they had these strange side entrances. Our slides shows them, but that won't pick up on the recording. But these strange side entrances that were entrances, but as Judge Daniel found at the district court level, Judge Daniel found in our favor on about 20 or 25 motions. I mean, in this case, was just motions practice left and right. And he found in our favor over and over again. But what he said was, having separate is inherently unequal. I mean, that's the idea here. You don't have one entrance for people to walk into the store, and the separate side entrance that, in his view and our view as well, you can't really even tell is an entrance for people who use wheelchairs. The case went up to the 10th Circuit. They appealed several of the rulings of Judge Daniel, and the case was reversed on a 2-to-1 decision on the issue of discrimination. The court finding that the separate side entrances were sufficient. They provided access to the store, and that was okay. And so again, and in this respect, the 10th Circuit is just a difficult place to litigate these cases. El Diablo is sort of a strange case. Okay. El Diablo is a strange case that some of you may remember on Broadway. There was a restaurant called El Diablo at first in Broadway. Strangely, an attorney that we work with looks straight out his office window at El Diablo on a daily basis. In that case, we filed what's called a motion for summary judgment, but it's basically just asking the court to say, here are the facts, and we're right on the law. And what they had done was they put in 2 elevated dining areas that had absolutely no access. And they had gutted the place completely. They took everything out of it and rebuilt it from the ground up. And they put in these 2 areas that were inaccessible. We said that you can't do that. You can't make alterations that are inaccessible. And it really was scorched earth litigation. litigator. This is a little odd because he practices disability rights law. In any event, so after all of that, we get this great ruling, and the ruling still stands. So that's handy. It's a district court ruling, but we have that before us. But the owner of the restaurant didn't do what he was supposed to, and the restaurant was closed as a result of the failure to comply with children code issues. So after all that hard work to get the court to rule in our favor, if it had been appealed, it might have been appealed. Who knows? We might have been successful, but it didn't matter. They declared bankruptcy, not because of us. It had nothing to do with us, but the restaurant.
All right, so moving on to those of you who may be considering doing some legal advocacy of your own, we just kind of want to contrast the two potentials that CCDC grew through and ultimately decided to start its own legal program. If you start your own legal program or have your own in-house lawyers, then you're going to have ready access to legal services. You just walk down the hallway, plop it on the lawyer's desk, and there you go. As opposed to having to go out and shop for outside counsel, who that process may take some time. You may ultimately not find an attorney willing to take the case for a variety of reasons. If you do have your own in-house counsel, that attorney is likely specialized in a particular area or field that you're working in, versus outside counsel, who you go to a lawyer that has a particular specialization. Depending on what you may need, you may ultimately find that you need both types of lawyers, both in-house and outside counsel. But that's going to be a consideration you're going to want to think about. Legal programs, your own in-house counsel kind of develop a symbiotic relationship with the rest of the organization that they represent, in that if it happens to be a lean year for the attorneys or a lean year for the organization, then perhaps the other can pick up some of the slack there. You can also rely on one another we rely on CCDC, for example, for some of the research that Deepti was talking about to support our litigation strategies. Outside counsel, of course, are going to come at an unanticipated expense. Unless you have enough money in your budget to plan for paying outside counsel hundreds of dollars an hour, that's going to be a lot of money out of your budget that you may not have planned on, versus a legal program where that is a budgeted for sort of thing, and you've got those funds ready and set aside. But speaking of funding, one of the other costs associated with having your own in-house counsel.
Keeping the lights on.
Exactly. So that leads beautifully into creative funding. As I don't recall if Kevin started with this or not, but when he founded the legal program within CCDC, he actually volunteered. One of the other attorneys who used to work in the legal program and has since moved on, as well as myself, we were able to work at CCDC because we went out and sought fellowships that would cover some of the pay for the time that we were working at CCDC before the organization was able to pay us. So you're going to have to get a little creative with some of your sources of funding. Social enterprise, a great example of that is the probate power program that we opened recently in CCDC. That was done through a social enterprise sort of investor thing. I couldn't tell you a whole lot about that, but that's another avenue you may consider. And of course, other investors, again, as Deepti touched on. Just be mindful that if you are a nonprofit organization who is considering doing in-house counsel, there are some bar association rules, I believe in every state, but I can tell you for sure in Colorado, that prohibit a non-lawyer from supervising the legal work of a lawyer. So you'll have to kind of build some walls there. And also sharing fees with a non-lawyer may be a little bit of an issue. So just to kind of put those bugs in your ear should you decide to do your own sort of legal program or other in-house counsel. I believe that's about it. This slide has our contact information. Should anyone want to get a hold of us, please don't hesitate to do so. And finally, our lovely disclaimer, because we are, of course, attorneys sitting here talking. Thank you all very much.
Thank you, that was great. We'll hand it over to Connie.
Great, thank you very much. My name is Connie Talmadge. I'm the Executive Director, as you can see, of the Colorado Lawyers Committee. I want to talk to you about a significant potential resource for your nonprofits in terms of providing some, or your being able to have someone who might help you with your impact litigation. The Colorado Lawyers Committee is a consortium of 78 law firms, very small firms to very large firms. Our mission, as you can see, is to improve conditions for children and the underprivileged and underserved through pro bono legal advocacy. And I'll talk in a minute about what is advocacy, because it includes a whole bunch of, it includes a lot of different approaches to problem solving. And we don't focus on individual cases. In order to improve conditions for children and the underprivileged, we only represent individuals where, in fact, the case that they have may impact other individuals. So recently we represented a 12-year-old girl on the autism spectrum who could not get services from under Medicaid from the state of Colorado, and our contention was that the state had an obligation to provide those services, and we took that case because we believed that if we could force the state to provide those services, they would have to provide them to our client, but also to other people who were similarly situated. We have a real interesting kind of structure. We have a very large staff. There are 3 of us. And this very large staff manages 800 volunteers annually who donated last year over 7,500 hours on somewhere between 25 and 30 projects. That's a lot of coordination. But the thing that we bring to the table, which I think it's important to emphasize, is our greatest asset is having access to legal talent to resolve systemic issues. And I will say to you, I've done this job for 17 years, and I have to say I've never, ever had a problem finding volunteer lawyers. The last time we created a task force, we do things in task forces, which is basically we bring together groups of lawyers from different law firms to work together. And the last time we created one, we had 45 people sign up. Do you know how manageable 45 people is when you're trying to resolve a problem? So we had to get creative and put them in subcommittees. Let me talk about the nature of our work a little bit. As I said, we do primarily high impact, legal advocacy and litigation. And my greatest regret as the executive director is that we cannot take on any more individual cases because they're very important. And in fact, it's the individual cases that other people see that they bring to us that get us the work that we do, but we can't do it. I just wanted to mention that there are 3 other kinds of things that we do. I'm not going to talk about these much anymore. We do run 4 legal clinics for individuals, and both here and in Greeley, and those are for individuals who just don't have access to lawyers and want to talk to a lawyer. And the folks in Denver, Legal Night is what that's called, and all of information about all of this is on our website. Come and wait for an hour or 2 to spend 15 minutes with a lawyer. And the lawyer's job is to either tell them, give them legal advice, which they're allowed to do in the clinic, or to send them to a different resource as to where they can find legal help. We don't take on representation from that. We also have a couple of education programs. We have a wonderful program that teaches kids about hate crimes, and it's done in the form of a fictional trial, and it's a fantastic program, and it takes about 2 hours, and we do it for free all over the state, and it's very engaging. And then we also run an election call center during election years where we answer questions like, where do I drop off my ballot, and my husband signed my ballot, and we found out that if your husband signs your ballot and then you sign his, they both count. But so you learn things in these. And then finally, I just wanted to mention our support for nonprofits. We have 2 great programs that are available to any small nonprofit. You have to have an operating budget of under approximately $500,000. That's the criteria. We do not want to be doing what private lawyers are doing for nonprofits who can't afford to hire a lawyer. So this is just for nonprofits who can't afford a lawyer. And we have two programs. We have something called Match.com. It's actually not called that, but that's really what it is. And nonprofits can apply. I think there will be a handout or a resource on, as part of this webinar, that you can look at the information for these two programs. And nonprofits apply through the Colorado Nonprofit Association. You don't have to be a member of the Nonprofit Association to take advantage of this. You submit your application, you tell us what the issue is. In Match.com, we don't do any litigation. These are just transactional lawyers. So if you have a question regarding a contract, an HR issue, you want to write a new policy manual or something, or you want to know what the law is for the Department of Labor regulations, it is possible that you can get help through this program. And what happens is we match lawyers up. Nonprofits submit their application, and then we send the request out to 150 lawyers, and sometimes they raise their hand and sometimes they don't. So we don't guarantee that we can find you a lawyer, but we've been doing this for, I think, 5 or 6 years, and we have helped over 350 nonprofits. And it's a really wonderful program. The other thing we do, you will see from the flyer, is something we called our Nonprofit Legal Audit Clinic. We do this twice a year, and it is a place where nonprofits can come and meet with teams of lawyers who will give them advice about the legal status of their nonprofit. They go through a nice long checklist, and nonprofits generally come out of that either patting themselves on the back about how great they're doing, or they come out of there looking like a deer in headlights. Like, I didn't know, I just wanted to help babies. I didn't know that there were all of these requirements. So it's a good place to get some kind of information about the health of your legal health of your organization. Our next nonprofit clinic is February 28th, and I believe the announcement just went out today from the Colorado Nonprofit Association. Again, that's where you sign up, is on their website. So that's the nature of our work. Let's talk about the areas of where our work. Children in the underprivileged or underserved is a very broad scope. We have projects in 5 different areas: children and education, civil rights and criminal law, poverty and public benefits, the community development nonprofit projects I just talked about, and immigration. What I want to talk about now is litigation, or actually it's high-impact legal advocacy. As I said, we focus on high-impact litigation. We don't represent individuals unless the issue is somehow, and the impact of our results are going to be broader. The Colorado Lawyers Committee is, I think, a well-kept secret. And I have to say that to some extent it's on purpose, because unlike some of our colleagues who also do impact litigation, like at the ACLU or even CCDC, their names go on their litigation. The Colorado Lawyers Committee is never a plaintiff. I am a lawyer, but I am never a signatory to the pleadings. Basically, what we do is we get groups of volunteers who come together, agree on what needs to be done, and then represent the individuals or organizations that are the plaintiffs. And so you won't hear about us. Sometimes judges know about us. When I first got to the Lawyers Committee, I got a call from one of the lawyers in a case that was in federal court, and she said, I've been asked by the Denver Post about where we got this case, and can I tell them? And I said, no. They go to court the next day, and they walk into Wiley Daniels' courtroom in federal court, and he looks over, and there are 4 lawyers from 4 different law firms whose probably cumulative hourly rate is, I don't know, $3,000 or $4,000, and they're representing the plaintiffs, and he looks at them and says, is this a lawyers committee case? So it is well known by some people, but our real focus is trying to get the people whose legal rights are being violated to get them help. We don't care about it. Now, I'm here today because we're not that well kept a secret, and we do need people to refer matters to us, because with a staff of 3, we don't have lots of people who go out in the field and talk to various people. We're just trying to keep the doors open and the lights on, and trying to keep the 800 volunteers doing what they're supposed to be doing. I want to talk about a couple of cases you might know. No, back to the previous one. Thank you. Many of you are probably aware of the state's attempt. Actually, it was successful, so I wouldn't call it an attempt, although it felt like that at the time, to consolidate the various computer programs for public benefits in Colorado. And I think they started with 6 and they ended up with 1, and they called it CBMS, Computer Benefits Management System. Well, when it was first implemented, there were, by the state's own estimates, 60,000 people who were not receiving their benefits within the times required by federal law. And we tried to get the court to stop the implementation. That was unsuccessful. It was curious, because I was told when I called up the volunteer to try and, one of the volunteers to try and get him to be involved, to donate his time, I said, oh, it's just a simple TRO. Well, the case was not resolved until 12 years later. And in that case, we ended up being kind of the leader of filing that lawsuit, and ended up reaching a settlement, and then they didn't comply with it, so we had to hold them in contempt, and we were successful in that, and then we reached another settlement. And I'm happy to say that just last year, this case got closed. That's very exciting. The other thing you may have heard about, we are the home of a lot of school finance cases. Unfortunately, with our Supreme Court, the Colorado Supreme Court, we haven't been as successful as we had liked, but we, for example, filed a lawsuit a couple of years ago called Lovato, and the Lovato litigation involved 70 different lawyers from 15 different law firms going through a 5-week trial in district court, all of them volunteering. I mean, it was an extraordinary effort. And it really is, we hope not all of our litigation is that large or that complex, but it gives you an example of some of the projects that we have done that you may know about. I think I want to talk about litigation as a tool. Again, there is individual litigation, some of which Andrew and Kevin talked about. I have to tell you, I think that's extraordinarily important, because without that, and without people actually taking on individual cases, we would never learn about the kinds of systemic issues, and that's just on the ground, and it's critically important. So I applaud the work that CCDC does. We don't do that work unless, as I said, it has a broader impact. We do only systemic. And then there is, we've talked a little bit about legal versus policy issues. People come to us all the time and they go, oh, I got this policy issue. And I say to them, you know, first of all, we have a pro bono lobbyist, but we don't do very much lobbying. That's the first thing. And second of all, we bring lawyers, volunteer lawyers, to the table to help you resolve your issues. Volunteer lawyers know nothing about policy except what they made up last night when they were at home talking to their spouse. So we're not an advocacy organization like the Colorado Children's Campaign or other organizations that focus on specific issues. Our focus is, how can we take the lawyers who are willing to volunteer their time and have them come up with systemic solutions that will impact lots of people. I want to talk about a couple of cases that really demonstrate a couple of things. Sometimes the threat of litigation. The Lawyers Committee has become known as having, which we do, a virtually endless supply of lawyers who are willing to stick around and file cases. So one of my favorite cases, I often think that as an executive director, I'm kind of like a parent, and I shouldn't have a favorite case, but I do. And I want to tell you about this one, because this one was really, it just warms my heart about how we were able to work it out. We found out from their own data that Denver County was not processing about 50% of their food stamp applications in the time specified by federal law. And, you know, this is food, and these people don't eat if they don't get their food stamps. And so we got the data, and there were lots of people implicated. I think there were 1,000 people a month who were being impacted. And so we went to Denver. I called up the city attorney and I said, this is not a personal call. He said, oh darn, what have we done? And we said, what you've done is you're not processing these applications. Do you want us to sue you, or would you like to fix it? We had a complaint in our pocket. We were all ready to go. And they said, oh, no. The mayor is running for governor, and we don't want you to sue us. And I said, how good was that political timing? And so how lucky were we? They completely revamped how they process food stamps. And they did it, and in the course of that, they found 10,000 pieces of paper in the caseworkers' drawers. So their non-compliance was even higher. And we sat there with them for 2 years, once a quarter for 2 years. We're going on and on. And we sat with them, and they completely restructured how they process food stamps. Within 2 years, they got their compliance rate from 50 to 98. It warms your heart when you hear about that. Similarly, a couple of years ago, somebody came to us and said, our clients are getting termination notices that their benefits, their medical benefits, that their other benefits are being terminated, and then the notice says, hi, you can have an opportunity to appeal, and if you appeal, we won't terminate your benefits until after the hearing. And what was happening was they were filing an appeal, and then their benefits were being terminated. And we're like, okay, so we put together a team of lawyers, and we had 7 or 8 people, and they got the complaint, and they did all the research. You know, as you were talking about, the research is critical because you have to know what you're talking about in terms of the people and in terms of the law. And right before we filed, I called up the Attorney General's office and I said, hey, you know, my understanding of the Constitution is that it's a notice and an opportunity to be heard, not notice and an opportunity to ask for a hearing. And he said, whoops. And so 3 weeks later, we met with the head of Healthcare Policy and Finance, the agency that does Medicaid benefits, and she gave us this long explanation about what had happened. And finally, at the end of it, she said, and we fixed it. And I said, excuse me? You know, we're all sitting there expecting some kind of pushback, and she said, we fixed it. And I said, why did you fix it? And she said, because you called us. And it turns out that the place filing their appeals was not talking to the place where their benefit, that was terminating the benefits. So they just didn't know. So that gives you an idea that sometimes the threat is enough. And people, the Colorado Lawyers Committee is well known enough in legal services circles and in state government that when I call them, usually I get somebody who will pay attention. You can do a lot before you get to the lawsuit. We have now, this is one of those cases that's kind of like the ADA cases you described, Kevin. There is a state law that was passed in 2011 that requires schools to adopt anti-bullying policies, to specifically include anti-bullying on the basis of sexual orientation and gender preference. And for some reason, there are 18% of school districts in Colorado who have not complied. I mean, they only had 7 years to do it, 6 years to do it, and they haven't complied. So we were approached as to whether we would take this on, and they came to us and said, will you file litigation? And we said, well, yeah, but could we start with something else? Maybe we could start with, and it turns out there's a rural school district where most of these districts are located, and the woman who runs the rural school district is a former anti-bullying expert for the state of Colorado, for the state agency. So we're starting with meeting with other organizations and meeting with school districts. Then we'll probably do a Colorado records request to the school district saying, hi, tell us about your anti-bullying policy and your changes that you made after 2011. And then we'll probably send them demand letters, and then we'll go to litigation. So I think in terms of when I think of legal advocacy and litigation, I think of 16 steps beforehand, because oftentimes you can resolve it. And I have to say that sometimes, you know, we've found, at least in this administration and a couple of previous ones, that people are really more than willing to solve the problem if you bring it to their attention. I want to say one other thing about, and I'm almost done, getting the evil eye from over there. We don't do lobbying, but very often we will use litigation as a tool for legislative change. And this has happened to us over and over and over again. The most recent example was a couple of years ago when we learned that there is a state statute that requires individuals charged with a misdemeanor to meet with a lawyer, to meet with a prosecutor before they get a lawyer. And we're like, really? Have you heard of the Sixth Amendment right to counsel? And so we put together our package, and we did our, put together our complaint, and then we called the Attorney General. And John Suthers was the Attorney General at the time, and he said, listen, this requires legislation, and I'm not going to spend my political capital on this, so you'll have to sue us. And so we sued them, and the lawsuit went on procedural grounds for a couple of years. And at the end of it, we work with a lot of other nonprofits, and the Colorado Defense Lawyers Association has a very strong lobbying presence in the legislature. They found somebody to sponsor a bill. That bill repealed the statute and provided $15 million for the Public Defender's Office to represent these people who were now going to have attorneys before they had to meet with the prosecutor. So sometimes we work in conjunction with other organizations and use it as leverage. I went over and testified, and the committee said to me, why'd you file this lawsuit? And I explained to them what was the problem, and they will, oftentimes the legislature will do something in order to avoid a very much larger price tag that would be associated with a win. And let me just say that I've given you examples of, the threat is enough, sometimes the leverage, sometimes you just have to litigate. I talked about the school finance case. 5 weeks, 70 lawyers, 15 law firms. I mean, and unfortunately that went to the Colorado Supreme Court, and they did not have the same opinion about discrepancies. Our argument was Colorado was not providing, or Colorado School Finance Act was not providing a thorough and uniform education. And we had asbestos hanging from ceilings in trailers in rural Colorado. We had kids in Center Colorado who were sharing 35-year-old textbooks, while kids in Cherry Creek had laptops on each desk. We thought that was some evidence of inequity. The Colorado Supreme Court sadly disagreed. And then finally, we have our very longest running case, which is now in its 39th year. This one, we just have teams of lawyers, and they get tired, and then we have another team of lawyers. For a while, we all laughed about the fact that you either have to go on the bench or die in order to get out of this case. But we do let people out, and that one has to do with land rights for people in the San Luis Valley and access to an adjoining ranch, which was part of their original land grant, to access to graze their animals and collect timber. The last thing I want to say is let us know if we can help. As I said, we have a small staff, so we don't do a lot of outreach. And one of the reasons I was very excited to be part of this webinar is because I really want people to know what we do, and you're not going to hear about us in terms of the newspaper. I consider it a major failing if our name gets in the newspaper. We're not reluctant to use communications, but let other people do it. It's not really us. So if there are issues you have that is a high impact issue, which is impacting a lot of people, and you're looking for pro bono legal services, we are your people. I think that one of the things that we do, there had been some discussion earlier about litigation is expensive. Litigation is expensive, but for the most part, the way we do it, we go out and get grants, or we get, when we were doing the Lovato cases, we got school districts. It's not really that, the expense isn't generally necessarily passed to the nonprofit. So, and we may ask the nonprofit to assist us in identifying sources of funds, because we don't do a lot of fundraising. We're supported mostly by the firms that are contributors to us. And my email and our website, our annual report, I've just been able to touch on a couple of things that we do. Our annual report is on our website, which is coloradolawyerscommittee.org. And my email is on the screen, and I encourage you, I'm reluctant to say this, but I encourage you to use it.
I know we're short on time, just a quick question. Do you have is there a percentage of cases dealing with children versus other underprivileged groups, or?
I will tell you that, except in the area that children is a difficult thing for us to do, and I'll tell you why. Most of kids' issues are policy. You know, we tried to argue, for example, mandatory kindergarten was required under, I don't remember, we had some argument for it, and really we could not. We did the research as has been discussed earlier, and we concluded that there wasn't, you know, there was no basis for making that claim. And we have had a children's task force that has been, except for the major foster care overhaul we did in the 90s and facilitated in the 90s, we've had a children's task force that has just been looking for issues. And the best we end up doing is kind of public benefits and Medicaid and that kind of thing. But mostly what we do, you know, we do civil rights, we do criminal law, we do a lot of poverty and public benefits. Yeah.
Well, thank you, Connie, and thank you all for your insightful presentations and sharing your expertise and experiences with us. We'll be posting these presentations and a few helpful links and resources online along with this webinar. Please don't hesitate to follow up with any Health Foundation policy staff if you have questions or suggestions, or if you need to contact our presenters. We're happy to help. And thank you for listening.